following program is from NET.
One segment of the American judicial process, law, is undergoing revolutionary changes to a very great extent from within its own ranks. Probably the most radical demands are coming from the young black lawyers who, to a very great extent, reflect their generation's attitude of commitment to the struggle of black people. In view of the overwhelming interest in law as applied to blacks and the new emerging role of the black lawyer, we have invited three brothers to express that new awareness. With me in the studio are Haywood Burns, director of the National Conference of Black Lawyers, who's been involved with the Angela Davis and Soledad brothers cases in California. Bill Clifton, a third-year student of law at the University of California in Los Angeles, and a board member of the National Black American Law Students Association. Kenneth Cockrel, member of a law firm in Detroit. Mr. Cockrel is also a member of the Black Workers' Congress. Brother Burns?
Tony, of all the lawyers in the United States, only about 1% are black, some 3,500 black lawyers. And the most significant thing I think that we recognize as young black lawyers looking around at our profession today is that there are almost that many black law students. So in a very short time, the majority of black lawyers in this country are going to be very young people, people under 30. And I think that this is a very healthy development, something that we're looking forward to, because there is a new spirit in the black bar. Well, I really don't think that we'd be justified in saying that there is no tradition of radicalism in the black bar in this country, because there's always been black lawyers who are willing to courageously stand up and do what they could to serve the community through their legal skills. It's just that the American system of justice and the American system, period, has been such that it's been very difficult in the past for black lawyers to make the kind of contribution that they would like to be able to make. In fact, at one time, blacks couldn't even practice law in this country.
Brother Clifton?
Well, I basically agree with what Haywood has said. We do have a new crop of black lawyers coming out of school, including myself, students in third, second, and first years, who evidence a new kind of desire to make this legal system move, to make this system responsive to black lawyers. We feel that as black law students, we have a responsibility not only to perpetuation of our own ranks, but to the people that we intend to serve. We feel that this system, while not being a friendly one to black people, certainly is not incapable of being moved. We intend to bring forth the strength and the power of new blood into a system to force the system to open itself up to black people. We view ourselves as interpreters of the law for black people. We see ourselves as being in the forefront, that people are depending upon us to bring to them new developments in the law, and we intend to use with all strength and vigor that we can muster to use this attempt, as long as allowed to exist in this legal system, to bring that force to bear on the very factors that continue to oppress us.
Brother Cockrel?
Yeah, I'd just like to say that my view of the overall system and the overall condition under which we live is one which leads me to the following conclusions. One, that the fundamental enemy that has to be attacked and smashed and destroyed rather resolutely by the people is, of course, the imperialist enemy. I think that the fundamental contradiction that we confront is imperialism, with its domestic variety being capitalism in this country. Obviously, there is a color caste contradiction in this society that produces a secondary contradiction of racism. My definition of my responsibility as an individual who is a part of a people's struggle is to defeat imperialism and to smash the supporting systems of racism and capitalism. In that regard, the responsibility of persons who have legal skills is to me very clear. One, they've got to use those skills in such a way as to demonstrate rather graphically to people that the American legal system is nothing but a functional appendage of an overall state apparatus that exists to do one thing and one thing only, and that is to serve the ruling class that owns and controls the means of production, that exploits the people not only of this country but of the world. So my view of the American legal system very simply is this, that it is simply a tool that is used by the imperialist enemy. It has got to be smashed and destroyed, and the overall system of which it is a functional part must be smashed and destroyed, and that a part of that process is that those who have legal skills should use those skills to do everything in their power to begin to demystify the American legal system so that we can convince black and other oppressed people that they are not justified in continuing to rely upon the operation of the American legal system as the vehicle through which our liberation will be secured. There is no shortcut. There is but one thing that will serve us in terms of liberation, and that is the smashing of imperialism and the seizure of state power placed in the hands of the people, guided by the proletariat. So that's our view.
Okay, Ken, could you define specifically what you mean by imperialism?
When I talk about imperialism, I'm talking about the fact that there is a form of economic organization inside of this country and inside of this world. The form of economic organization inside of this country is one whereby the fundamental means of production, the factories, the mines, the basic economic infrastructure is controlled by a relatively small number of people. That on the other side you have labor, the persons who enter the economy and have nothing to do but exchange their labor, work, for wages. The wages are generally very small, just that minimum that is necessary to sustain them on a minimum level, and the rest of that is what we call surplus value. In a Marxist-Leninist analysis, that is surplus value is exploited, it's characterized as profits, it goes to the ruling class. When the domestic capitalists, the cats in America, the ruling class, enter other countries in two ways. One, they enter by financial penetration, that is to say investment in other countries. You see it everywhere, South Africa, Chrysler Corporation, all over the world. You see it with the wage price free situation that's taking place right now, for example. When they penetrate other countries through the use of the exportation of capital or direct investment in those other countries, and when they couple that, of course, with the use of this elaborate military machine to smash national liberation struggles that take place in other countries, which struggles might result, for example, in the expropriation of the ruling class over here, taking their companies over, this kind of thing. So when I talk about imperialism, I want to put it, like in terms that I hope can be understood. I'm simply talking about capitalism leaving the borders of the United States, number one, through the mechanism of financial penetration and the acquisition of markets in those other countries, and the use of the fist, the gun, and the club, and the force of the armed military apparatus of the state to smash liberation struggles wherever they might occur in the world, because those liberation struggles are headed fundamentally in the direction of socialism and therefore are unalterably opposed to the continued existence of the capitalist rule and domain over the entire world. So that's what I mean by imperialism. It is the fundamental enemy. We understand that we are black. We understand that our oppression has a national character, but we also understand that if it were not profitable for the capitalist and the international capitalist to be called the imperialist, if it was not profitable for those elements to subject us to exploitation on the basis of our race, they wouldn't do it. It simply wouldn't make sense. So what I'm suggesting is, to whatever extent we are discriminated against, and that's very clear to all of us, we've still got to recognize that fundamentally we're dealing with a system that is run on a logic that says we must extract as much profit as possible for those who own and control the means of production, and the hell with the rest of the world. So I'm saying that that's the fundamental enemy. The same Chrysler Corporation in America that can join forces with such things as the Urban Coalition and talk about redeveloping inner cities and solving those problems are the same Chrysler corporations or Ford Motor Companies which are exploiting and extracting surplus value from black workers under apartheid system in South Africa, for that matter over the entire world. So that's what I mean, just generally speaking, Tony, about imperialism. It is our enemy. The people have the capacity, the people have the right, the people have the duty to rise up, to seize power, and to run this society in such a way as to produce not profit for the few, but to produce on the basis of meeting the needs of the people who live in the world.
Well, as a lawyer, you used the word to smash and destroy. What functionally could you do as a lawyer in terms of...
There's a number of things, Tony. I just want to cite one example, and I think the brothers could probably join in at some point. In terms of this, I cite one example of a case that I was involved in. I was involved in a case called the James Johnson case in Detroit, where there was a black worker who was born in Mississippi who had been subjected to conditions of a colonialistic kind of form of upraising. He was born on a plantation and so on. This brother finally made it through in the course of his life up to about age 30. He found himself working in an automobile plant, a Chrysler Corporation plant in the city of Detroit. The conditions at the point of production where he was caught up in those contradictions were such that finally one day this brother got fired. He went home, got a carbine, returned to the plant, shot down 2 foremen and 1 job setter, we defended this brother. We had the following objectives in mind. One, we had the objective, of course, of demonstrating as clearly as we could to people the contradictions that exist, you know, in terms of workers at the point of production. We exposed the conditions of the plant. We exposed the role of international imperialist corporations as being essentially exploiters of the surplus value of workers. We exposed the racial conditions, the colonial conditions, if you will, as Fanon writes about him in The Wretched of the Earth. We exposed the conditions of his upbringing. We demonstrated to the people that, in fact, this man was not responsible for those homicides, that, in fact, the Chrysler Corporation and the existence of a racist imperialist system which has denied him systematically every possible opportunity for productive participation in life were, in fact, the true culprits in this case. We were able to convince the jury through a number of mechanisms that this was, in fact, the case, and this man who shot down these 3 people was acquitted. The importance of that case was understood not only in Detroit, not only throughout the country, but indeed throughout the world. Even Time magazine had to give it a play. But my point is that that was a classic instance in which you go into court. You don't go into court on the defensive. You don't go into court saying that, like they style a criminal prosecution, the people of the state of New York or the people of the city of Michigan. We indicate to the jury the people ain't got nothing to do with no crap like this, that it ain't the people, that it's the state apparatus, the prosecutors, and the judges who are nothing but flunkies for the imperialist ruling class, you know? They understood that. We demonstrated to the people what those conditions were. The people indicated that they had had their level of political consciousness raised to such a point that they were not prepared to simply blindly ratify a judgment that would call this man a criminal. He was not a criminal. The system is a criminal. The imperialists are the criminals, and they understood that. Classic way. So what I'm trying to say in closing, okay? A lot of people say that you cannot be revolutionary and be a lawyer. A lot of people say that when you work inside of the legal system, you're working as a reformist. I don't have that view. I don't think Haywood has that view. I don't think that Bill has that view. You go into the court and you try to do 2 things, particularly where there are people who are involved in struggle or where there are people whose concrete situation is one which can be used to educate. You go in to demystify the system. You go in to expose the contradictions of the legal system. You go in to exploit every possible option that still exists in this kind of like pre-revolutionary period. And I think that that's a very positive and, you know, like incredibly important function. There are other examples that possibly we can get into at a later time, but that concretely, brother, is what I mean.
I agree with a lot of what Ken said. Ken and I have known each other for a number of years, and we've functioned together. And Ken, in fact, is a member of the National Conference of Black Lawyers and one of our stellar members.
Yeah, and Haywood was once my lawyer. He defended me when they were trying to disbar me.
So we're in substantial agreement in large numbers of areas. But one of the things that I did feel that Ken said that I'd like to raise from perhaps a different perspective is the whole question of this confluence of caste and class in this country when it comes to the law, racism in American law, and the class bias in American law. Because I'm not sure that I can agree 100% with Ken's analysis about the nature of the legal system here when it comes to the question of racism. Because I think, in fact, it's been demonstrated in some areas that the kind of apartheid that has existed in this country has, in some cases, existed even though it was not in the economic interest of those persons who were in power. I think, for example, of the situation in the South for a long time. You did a strict economic analysis. You could see that the kind of apartheid that existed there was not economically in the interest of the persons in power. And it was in that kind of a situation that the racism that is part and parcel and pervasive of this country was the most important and salient factor. And I think that's the kind of thing that I have to focus on when I come to the legal system today. I don't rule out the kind of class bias that Ken is talking about, but it seems to me that black people know something the Kerner Commission said just a few years ago, something that we've known all along, and that is that racism pervades this country. And the mistake that many people make is that they think that the law somehow stands outside of that, and there's no way in the world that we can say that. Rather than transcending the racism in this society, the law reflects it. And I do agree with Ken, however, that we're not going to get the kind of change in the legal system that we need until we get the kind of change in the social system. Because we're living in a society that has misallocated its resources, whose priorities are inverted, whose values are warped, and the legal system just reflects that. And as black lawyers and as black people, we just have to address that situation and use our skills to the extent that there is elasticity still left within the legal system.
Well, specifically, how does law reflect?
I think in a number of ways. The most overt way that it reflects this kind of racism that I'm talking about is in the attitudes of the persons who run the system. We're in a system where constantly we come into contact with judges, with district attorneys, with clerks, with bailiffs, who just are racist. And it's clear from what they say and what they do. It's clear from perhaps their failure to use a courtesy title in talking to a black person, or perhaps the difficulty you have in forming a corporation if the corporation happens to have black in the title. Those kinds of things are most overt and easy to put your finger on because it's old-fashioned racism. But perhaps more subtle and perhaps more germane to our discussion this evening is a whole question of institutional racism, where no longer do you have, as you once had, laws which say blacks can't do this or blacks can't do that, or blacks get a different penalty for a crime than whites get. No longer do you have that explicitly articulated. You don't have judges making decisions as you once did, using race as a basis for the outcome. But operationally and institutionally, the law operates in that fashion to the disadvantage of the poor and the non-white. When you look at the functioning of the money bail system, for example, and you see two people come into the courtroom, otherwise similarly situated, same kind of employment record, same kind of length of time in the community, roots in the community, except one of those persons has money and the other person doesn't. And the result of that is the moneyed individual walks after the arraignment, and the other person goes behind bars and stays there for weeks, months, and sometimes in this system years before ever coming to trial. Yet they're equally presumed innocent. Institutionally, that's operating to the disadvantage of the poor and the non-white. You look at the procedural rules and substantive doctrines of the law, and you can see in the consumer law the creditor bias. It's just built in from the doctrine. If the doctrine were applied even-handedly, you'd still have a discriminatory impact because the law, the way it's set up, works to the advantage of the landlord and landlord-tenant law. And you look at the administrative procedure, and you see the kind of protections that we guarantee for persons whose interests are the interests of poor people, the people who are on public assistance or people in public housing. The kind of protections we guarantee them in a due process setting are very, very much less than what you see in another administrative setting, perhaps with the ICC or the FCC when commercial or property interests are involved. So I think that every juncture we can see institutionally, endemic in the law, part of the law, this built-in inequality, this structural inequality. And those are the kinds of things that we're trying to address. But I think we make a mistake if we think of the law as a panacea, because we're not going to cure these kind of problems only through the law. The law is just one of a number of useful tools in this overall process. And I think that's part of the perspective of the young black lawyer, that he doesn't think that he's got the answer, but only part of the answer.
I think that, Tony, I think that basically black law students have serious problems in attempting to address themselves to the problems that Ken and Haywood were elaborating on. I think that mainly black law students many times view themselves as being a new vanguard, a new leader in this fight against constant oppression. But I think that if we're to be realistic about present situation, we are only allowed to operate within this system as long as the powers that be permits us to operate. And I mean, we must go in there with this in mind. I think that disbarment should be a reality towards any black lawyer who intends to make any change in this system. Not that, you know, this is a means of doing it, because I'm certainly not sure of that. As a matter of fact, I'm becoming less and less sure daily. I think the situation that Haywood mentioned, such as the discrepancy in the bail situation, there was a case involving Angela on the West Coast. In this situation, she was not even allowed money bail. She could not be bought out of jail. A case involving a white girl in Washington, D.C., who was charged with being an accessory to a police murder. She was allowed out on bail on her own recognizance with the condition that she be in after 10 o'clock. And, you know, situations like this that require a great deal of reflection on what's going on. And I think that as black law students, we have a responsibility not to become so entrenched and engrossed in a landlord-tenant creditor's rights and those kinds of classes where we lose contact with the reality of the situation. That is that we have a tremendous job in front of us, and we must become as creative and as innovative as Brother Ken has been in defending our people.
What are some creative and innovative things that you think would be operational?
Well, certainly the first thing that I think of is that black law students should not wait to be certified by the American Bar Association, that we should be certified by the National Bar Association.
What's the difference?
The difference is that the National Bar Association is a black organization of legal minds, and the ABA is predominantly white, and it is, for the most part, exercises control over bar examinations and selection of judges and what have you around the country. So I think that our whole system of values has to change, that we feel that, at least I feel personally, that the NBA can certify me, can administer a bar examination to me, and armed with that, I will walk into court and appear in court and represent my people. I don't need the ABA to tell me whether I'm qualified to practice law or not. That's just another vestige of racism that's entrenched in the whole institutionalized pattern of racism that pervades the society, and it creeps out and grabs you at every segment along the way. So these are things that we have to seize the opportunity. We have to take the initiative, and we have to move ahead. No one's going to do these things for us, and as long as we have certain vehicles and certain mechanisms available to us, then we must move ahead to do them ourselves. We can't wait on people to, bring us things. They're not going to come that way.
I'd like to throw something in on this, okay? I mean, like, I have, like a kind of a different view. I mean, it was interesting. Haywood, in one sense, disagreed with me, but then each of his factual examples indicated really the class character and the economic content of the oppression that people are experiencing. For example, he cited landlord-tenant, which is as fundamentally classic an instance of economic oppression. But I just want to be very clear on the fact that it's crystal clear that we are black. It's crystal clear that this is a racist country. I mean, that is axiomatic. The point that I'm trying to make very simply is this, that we've got to proceed beyond an analysis. Our analysis has to go a little bit farther than the mere expression, of course, of black is beautiful. Not that I'm saying that that's your position. I mean, black is beautiful, I'm beautiful, you beautiful, we all beautiful. We look in the mirror, we see we're beautiful, we still oppressed. We've got to have an analysis that understands the operating dynamics in this system. And my position would be that the fundamental contradiction that is operating in this society or in the world is the contradiction that arises from how a society organizes itself for production. That's simply a fact. And you cited that in each of your factual instances. You talked about black and non-white. You know what I mean? Whether you talk about jail, whether you talk about some other instances, we know that the racist thing exists, just as Haywood was laying it out. I mean, you could take a situation like where, for example, when the dope thing wasn't too big among whites, then it was a hard beef, 10-year felony and all the rest. When the little daughters of the board chairman and so forth began to get high and get busted, you suddenly found a lot of discussion about making possession, say, of marijuana, misdemeanor, 90-day crack, and so forth. We clearly see those manifestations of both class and race, and we don't disagree. I mean, I just want to be very clear to whoever's listening that there is some fundamental...
Well, feel free if you want to disagree.
There's fundamental agreement here. We can disagree about certain things, but our fundamental analysis is the same.
Let me ask you this. Listening to you, the concept now political prisoners, which is a rather contemporary term, is one that frequently used. What, in anybody's estimation, is a political prisoner?
Go ahead,
Well, I think in the most narrow sense, Tony, it's someone who is being prosecuted because of or in connection with his or her political views or political activity. But I think that it would be really much too simple if we left it at that. I think that when you talk about the legal structure, as we have in this program, you have to look at the way in which the entire social system is set up in such a way so that when a person is caught up in the legal system, quite often it's a function of his race and of his class, the confluence, the flowing together of the racial prejudice in this country and the class prejudice in this country. And so that in a larger sense, I think that almost any time a poor person or a non-white person gets caught up in the legal system, there is a definite argument for saying that that person is a political prisoner. The clearest example of a political prisoner, I think, is somebody like Angela Davis, who was a thorn in the side of the state authorities in California, someone whose real crime was being a radical black woman in a male chauvinist racist society.
Let me expand on that question of political prisoners. It seems at this point that it's about ready to go out of vogue through overuse, and I am in agreement with what Ken said about black people in jail. Angela certainly is a classical example of a political prisoner, but all black people in jail are political prisoners. The situation that we're caught up in is a conscious political decision made by this government, made by this system, and it depends upon ordering of classes. The classes must all be ordered in order for the system to continue to function. So therefore, when any element is interjected that disturbs this ordering, it becomes a political act. It becomes an act against the state. That's so right. Therefore, even black folks jacking up other black folks are political prisoners.
That's right.
In that they disturb the order of things. And they become political prisoners. And we should be very clear, James Earl Ray cannot be a political prisoner. He cannot be one because he's maintaining the status quo. He's trying to stop this disordering. So we must be very clear when we talk about political prisoners, for fear that the term will die out of overuse, and that they will take the fire out of the term. It's a very explosive term to label one as a political prisoner. And one means that this country has been able to remove that element is through co-optation. And co-opt political prisoners. Next thing you know, Mickey Mouse will be a political prisoner because it will be advantageous to them to put political prisoners on the same level as Fantasyland. So we have to be very careful when we throw around a term such as political prisoners, that we are aware of what it actually means and the impact that it has on other decisions.
In regards to the timetable, is the system going to change fast enough?
Well, I don't know if the system is going to change fast enough, but I mean, I know this. I know that the level of consciousness of oppressed people all over the world and in this country and among black people is raising. I know that history is on our side. I know that it is historically necessary for us to smash imperialism and win. I'm confident that we will win, and if it takes 1,000 years, or if it takes 10 years, or if it takes a day, the longest journey begins with a single step. We're absolutely confident that we are in fact going to win. We're absolutely aware of the fact that the capitalist system, the imperialist system, the racist system is decaying everywhere you look, and the indexes of that are legion throughout, like this country and throughout the world. So it's not a question of like, when will we be able to plant the flag and say that we've seized state power in the name of the people? The task is to be engaged relentlessly in struggle and to expend as much effort and as time as one can, on behalf of that. I mean, we're confident we're going to win. We know we cannot lose, and it doesn't make any difference when it comes. The beautiful thing about life nowadays is to be engaged in the struggle to bring that about.
Do you feel that with your level of consciousness and your attitude about being a lawyer that you will, 1, finish law school, 2, be admitted to a bar?
I'm certain I'm going to finish law school, or somebody's going to have a lot of answers for me. The second question as to whether I will be a lawyer, I don't even know what a lawyer is. I intend to advocate for my people if it means being on a soapbox. The third part is whether I will be admitted to a bar is, of course, a very serious kind of question, because the bar exam, just like every other area of institutional racism, is not without control, is not beyond control, and they may control those who are admitted and those who are not. So that there will be another series of answers that I'll have to have for not being admitted to the bar. If not admitted to the bar, I don't know what I might do. I might just start appearing in court and start representing people, and then call on Ken to defend me.
Right on.
You see, because I'm really not concerned with that question as much as what I feel that I'm equipped to do. I don't even need to practice law for that matter. I'll hold church group meetings, and we'll practice street corner law. I'm not even concerned with that.
Thank you very much. This discussion with the young black lawyers undoubtedly has unveiled some very new philosophies, new attitudes. It's very clearly pointed out there will be some change, no matter how minor in the system, and there's been a definite change in the philosophy and ideology of blacks who will practice law.